Hearing in the matter of the King on the application of Finch on behalf of the Weald Action Group against Surrey County Council.
May it please the Court, I appear with Mark Willers, King's Counsel, and Ruchi Parekh for the appellant, Ms. Finch, on behalf of the Weald Action Group. Mrs. Harriet Townsend and Dr. Alex Williams appear for the first respondent, Surrey County Council. David Elvin, King's Counsel, and Matthew Fraser appear for the second respondent, Horse Hill Developments Limited. And Richard Mools and Nick Grant appear for the third respondent, the Secretary of State. Your Lordships and Ladyship also have the benefit of written submissions from 4 interveners.
Yes, thank you.
Counsel for the appellant are sharing the privilege of advocacy today. I will open the case and address grounds 1 and 2, and my learned friend, Mr. Willers, King's Counsel, will address grounds 3 and 4. If it suits the Court, I propose to give my submissions in the following form. First, I will give an overview of the appellant's case, setting it out in 8 propositions. Second, I will touch briefly on the factual background, including what is agreed. Third, I will make general submissions on the interpretation of the Environmental Impact Assessment, or EIA, regulations, which are relevant across the appellant's case. Fourth, I'll address ground 1, including the case of Abraham, and then finally, briefly, ground 2.
Thank you.
Mr. Willers will address grounds 3 and 4 and the OEP submissions. So by way of overview, my lords and my lady, this appeal concerns the statutory construction of the Environmental Impact Assessment regulations. These regulations impose a set of procedural requirements which are aimed at achieving the protection of the environment in relation to a set of specified factors, one of which is climate. The focus of the procedural requirements is providing, quote, as full a picture as possible per Blewett, para 41, to the decision maker before he or she makes any decision allowing a project where there is, quote, any serious possibility, per Bateman, paragraph 75, of a significant effect on the environment.
You're going a little bit quickly if you're asking us to make a note or expecting us to make a note as we go. So
I'm grateful, my lord. I will slow down.
But give us that last reference again.
I will. So the serious possibility reference is in Bateman. Your lordship will find it, in fact, at core volume 2250. So the proposition is that the procedural requirements are going to give as full a picture as possible to the decision maker where there is any serious possibility of a significant effect on the environment. And so the appellant's case can be encapsulated in the following series of 8 propositions. Proposition 1. Regulations 4.2, 18.3 and 4, and Schedule 4, paragraphs 4 and 5 of the regulations, impose a legal obligation to assess the likely significant effects on the environment of a development. And included within effects is a wide range that deliberately covers comprehensively the field of possible effects of the project. This includes direct and indirect effects. Proposition 2. The meaning of the words indirect effects is a matter of statutory construction. The plain meaning of these words, their context, and the intention of Parliament, as well as the purpose of the legislation, all run in the same direction. Proposition 3.
Just on that, say the intention of Parliament.
Yes.
I mean, these regulations were to implement the directive. So,
precisely so.
And I don't think anyone says that they failed to do that. So
yes.
we, in fact, go back to the purpose of the directives rather than... becoming preoccupied with the intention of Parliament.
My Lord, yes, and your Lordship anticipates a submission that I would make, which is that one looks to the directive for what the intention of Parliament encapsulates. Proposition 3. The plain meaning of the words, indeed the dictionary definition of indirect effects, is not direct effects. They are effects which are mediated by intervening processes. This purposefully captures a broad range of effects and, as my Lord Sales just mentioned, reflects the intention of Parliament to implement the directive, which also intentionally uses broad language to achieve wide protection of the environment. Proposition 4. Rationality plays no part in the exercise of statutory construction. An effect is either direct or it is not. There is no inherent discretion built into that term, properly construed. It is not an elastic term, depending on the views or the planning judgment of individual decision makers. To allow each decision maker to establish the scope of the term such that in similar circumstances, two different outcomes would be reached, would be contrary to the objectives of the directive and the regulations, and would be a recipe for uncertainty. Proposition 5. The extraction of the oil is part of the development for which permission is required. Indeed, it is the part that triggers the application of Schedule 1 of the regulations. It is thus not merely the purpose of the development, although
Extraction of the oil.
the extraction of the oil.
Yes.
So the extraction of the oil is not just the purpose of the development, although it plainly is that. It is the development. So understood, the question of whether the greenhouse gas emissions from the combustion of the oil are indirect effects of the project become clear because the project is extraction. They are, and this accords with the common sense understanding of the process and its effects.
Well, I understood your written case to be that it's not just the extraction, but extraction for commercial purposes.
My Lord, yes, and your Lordship rightly reminds me that the commercial purposes are important. They are part of what brings the project within Schedule 1. And so the extraction for commercial purposes forms the overall purpose of the project and defines the project in EIA terms. But the key point of Proposition 5 is that the project is not simply the physical works by which extraction is achieved. The project is the extraction of the oil, the extractive process for commercial purposes. Proposition 6. The fact that there are intervening processes, including refinement, between the extraction of the oil for commercial purposes and its combustion is the reason that the effect of greenhouse gas emissions from that combustion is indirect. As a matter of proper interpretation of the regulations, refinement of the oil is not capable of being a reason to exclude downstream emissions from being indirect effects of the extraction of the oil for commercial purposes. Proposition 7. This is fortified by the fact that the downstream emissions of greenhouse gases caused by the extraction were agreed by all parties to be a material planning consideration.
At all levels? At all levels of these proceedings?
My Lord, yes.
That's all right.
As a matter of law, the causal question is answered if the effect is a material planning consideration per right and resilient energy, paragraphs 32 to 34.
And where is that in the bundle?
That is core volume 1602.
Would you like us to look at that, or
My Lord, not
come back to
yet.
it?
And in particular, because Mr. Willis, King's Counsel, will address the court in detail on that in due course.
I see. You'll come back to it then.
Yes.
Yeah.
That is because, so the causal question is answered because a material consideration must be fairly and reasonably related to the development. And if that is so as a matter of law, then logically and as a matter of law, it cannot be too remote for the purposes of EIA, particularly given the breadth of the term indirect effect. And finally, Proposition 8. The gatekeeper function, if I may call it that, i.e., the function that prevents too much from being included within EIA, is not the meaning of indirect effect, or indeed of project, given that, however project is defined, EIA may need to embrace a wider consideration of effects. And for your Lordship and Ladyship's note, that is CAT, core volume 1410.
And what is the gatekeeper in these circumstances then?
The gatekeeper in these circumstances is threefold. First, the requirement for the effects to be likely. Second, the requirement for the effects to be significant. And third, the requirement that an EIA only need provide the information that it is possible to obtain having regard to current knowledge and methods of assessment. That third proposition is Khan, for your notes, 125 to 128 in the paragraphs, core volume 1528.
Are you going to come back to that too?
My Lord, yes.
I'm sorry, which were the paragraphs did you say?
125 to 128.
Thank you.
So, my lords and my lady, those are the 8 propositions, and on those 8 propositions, the appellant builds its primary case. That case is that the Scope 3 downstream emissions of fossil fuel development, i.e. the emissions from the burning of the fossil fuel extracted from the site, are, as a matter of law, in light of the correct interpretation of the regulations, indirect effects. And the appellant says that there are 2 separate routes by which the court can reach this outcome. The first is that regulations 4.2, 18.3, 18.4, and Schedule 4 of paragraph 5, ones I mentioned earlier, and to which I will take the court in due course, properly understood in light of the language, context, and purpose of the regulations, requires the downstream emissions of fossil fuel extraction to be indirect effects. This stems
For any sized well, or a well that falls within paragraph 14 of the directive?
for any extraction that falls within the directive for any reason.
Right.
Any extraction that is captured by the directive, whether Schedule 1 or Schedule 2, but plainly, none of the number of extractive operations that fall outside of the directive or the regulations. Because the appellant has always recognised, and this has never been part of the case that's been put by the appellant, although it is said against us often, the appellant has always recognised that EIA applies to a small proportion of development. It is not a regulatory system designed to deal with all effects of extraction. It is that set of procedural safeguards that I mentioned earlier, which apply only to those projects falling within the regulations, which, because they fall within the regulations, are projects that are prima facie, if you will, likely to cause a significant effect on the environment. And the point of the assessment process is to determine the extent to whether that is so and provide the decision maker with that information.
Right, when you say prima facie likely to cause significant effect,
Yes.
is that submission addressed to those projects for which EIA is mandatory, or does it encompass those where there has to be a screening decision before you proceed to EIA?
My Lord, it encompasses both, because the screening stage asks those who are looking at the project to decide whether it should be EIA development based on whether there may be likely significant effects.
It was really your reference to prima facie likely to cause significant effects.
Yes.
I mean, isn't that part of the purpose of the screening process to decide?
My Lord, absolutely
whether it is or
so.
not?
Yes, but once a project is screened in, then it is screened in because it is likely to cause significant effects. And so, prima facie one, if in a climate-related circumstance, would be considering whether downstream emissions should be assessed. And your Lordship may recall that there is a paragraph in our written case which in fact draws out the point that indirect effect, whether it is in Regulation 15, which is the scoping regulation, or any of the other parts of the regulation, must mean the same thing.
Yes. Sorry, which is that paragraph?
My Lord, I will look to my left and right to be reminded of the
Yes,
paragraph.
thank you.
I'm very grateful. So I was setting out what the two routes were that the court can get to the appellant's primary case. The first route was essentially a route of standard statutory construction, i.e. the language read in its plain meaning, understanding its purposes, and applied to fossil fuel development requires that indirect effects include downstream emissions. This is because of the nature of the class of fossil fuel development, which is the extraction of hydrocarbons for commercial purposes destined for combustion, which inevitably causes greenhouse gas emissions. My Lord Sales, for your note, the reference to Regulation 15 is paragraph 119 of our written case.
Thank you very much.
Core volume 129. So that's the first route. The second route is if the court determines that the term indirect effects does admit of some elasticity, i.e., it is the type of term in which a measure of discretion is given to the decision maker applying that term. because of its elasticity. If that is the case, which we say is not, and our primary cases is not, but if the court is against us on this, then the submission is that the question of whether the downstream emissions of the fossil fuel extraction are indirect effects permits of only one rational answer.
In the circumstance of this case?
In the light of the incontrovertible nature of fossil fuel development in general, the way that greenhouse gas emissions and climate impact work. So that's a class-based argument for any fossil fuel development that falls within the scope of the directive. Our submission is that there is only one rational answer to whether the downstream emissions are indirect effects.
And how do we know whether it is a development falling within the scope of the directive and drives this conclusion in your submission?
Well, either it would be a Schedule 1 development, and then it would be clear, or it would be a Schedule 2 development that had gone through the scoping process. And for the purposes of the scoping process, the decision maker should take into account the downstream emissions. But it will be a question of judgment for that decision maker whether those emissions are likely or significant.
But is that the case for all the different projects within the scope of the regulations, or just those which are for fossil fuel extraction?
The appellant's case is just those which are of the fossil fuel extraction, and that is because of the unique nature of the direct, I better not use the word direct, so don't write that down, because of the unique nature of fossil fuel development.
Well, inevitable is the word.
Inevitable is the word. And it's essentially a simple point. Fossil fuel development is extracting hydrocarbons. Hydrocarbons are the prime cause of greenhouse gas emissions through their combustion. And indeed, that was the change in emphasis that was brought about by the 2014 directive.
Well, I understand your submission to be, well, it wasn't introduced, this particular paragraph wasn't introduced for the purposes of, or arising from a concern about greenhouse gases which are emitted during the course of extraction of the oil from the ground.
Correct.
But from the combustion of the oil once it's been extracted.
Correct.
That, I understand it is your point.
Precisely so, my lord, yes. My lords, just to finish the general propositions, the appellant's fallback case, which Mr. Willers will address, is if the court is against us on all of that, then Lord Justice Moylan's approach will be suggested to be the correct one. So may I take then
Would you
very
just
quickly
summarise what you say that
Madam.
approach is? Is that because there seems to be some dispute between the parties as to whether Lord Justice Moylan's approach was simply that the reasoning was not adequate for why the downstream emissions were excluded? Is that the point you're relying on at this stage?
My lady, it was that, but it wasn't just that. So Lord Justice Moylan, I think the way we put it in the written case is he went almost every step of the way with the appellant on the approach to understanding the regulations, on the approach to understanding Abraham and what the end product is, on the approach of focusing on the emissions. But in the end, he held with the majority that it's a matter of planning judgment whether it is an indirect effect. And so that's why this is the appellant's fallback case entirely, because it's out with the purview of the downstream emissions being as a matter of law, either because of statutory interpretation or only one rational answer, direct indirect effects of the development. My lady, that's, I'm reminded, paragraph 129 of the Court of Appeal's decision, core volume 403.
And you say Lord Justice Moylan went wrong. He should have taken a stronger line.
My Lord, yes. Just at the very final part of the Lord Justice's reasoning, and indeed Mr. Willers will deal with this in detail, but in short our case is that with respect, the Lord Justice didn't grapple with the fact that environmental impact assessment may be required even where it turns out in the end that there will not be a likely or a significant effect. So if I can give an example, and I'll draw on the frack-free Rydale case, which was the case of gas going to the Napton power plant.
Sorry, what was it? What was the name of the case?
The frack-free Rydale case. That is the Friends of the Earth case. Friends of the Earth and North Yorkshire Council in the core volume at 1459 onwards. And in that case, I don't look at the findings at all, I'm just taking the facts as an example. Gas was being extracted and it would be fed into the Napton power plant to power it. But that power plant was subject to an absolute permit preventing emissions over a certain level. So no matter how much gas from the development went into Napton, only the same amount of greenhouse gas emissions overall would have been emitted. That's a circumstance where there's an indirect effect from the development, which is the downstream emissions from combustion of the gas. It may not in the end be a likely significant effect because it's controlled separately by the permit that applies to Napton. But nevertheless, the appellant says that would be an obvious circumstance where EIA would be required in order to demonstrate why the effect is neither likely nor significant. And what Lord Justice Moylan did was he was concerned about that occurring, there being a fossil fuel development where in the end there might be no impact from the greenhouse gas emissions. And he used that as his basis for determining that it should not, as a matter of law, be an indirect effect. If I may then move on very briefly to set out some of the factual background. First, it is agreed, and I've covered this in the principles, that the project or the proposed development is both the physical works, i.e. the operational development, and the extraction. And as your lordships and ladyship have seen, we rely on that. It is also agreed now that there are four things that are inevitable. First, the oil produced from the site will be refined. The oil produced from the site will be refined. Somewhere, but it will be refined. Second, that it will eventually undergo combustion. Third, that this combustion will produce greenhouse gas emissions. And fourth, that these emissions will have a significant harmful impact on the climate. Now, just pausing there.
Sorry, so these particular emissions or greenhouse gas emissions generally?
These particular emissions in the sense that they will increase the impact overall of greenhouse gas emissions on the climate.
So if these are agreed, are they set out somewhere? Or is this your summary of what?
So this is my summary. I take it from the Statement of Facts and Issues and those matters that are agreed there. It's CV 82 to 92.
Paragraph what of the Statement of Facts and Issues?
Again, I'll look to my right for the specific paragraph.
I mean, it was really the fourth that I was sort of interested in. The first three seemed to be
Yes.
pretty
it's-
controversial. It was really the fourth,
Yes,
or the
it's
way you put the
certainly-
fourth, which, since you're
Yes.
saying what is agreed,
Yes.
I
It's
just
certain-
wanted to be clear about that.
My Lord, you're absolutely right. And it's certainly right that it's agreed that greenhouse gas emissions have a harmful impact on the climate. That is what is agreed.
What is agreed,
Yes.
right? Agreed.
Greenhouse gas emissions have a harmful impact on the climate. And that's CV 89. And then maybe I ran ahead because if one takes that with what the senior president recorded in paragraph 71 of the Court of Appeal's decision, if your lordships and ladyship wish to look at that, that's at core volume 386. Paragraph 71. The senior president recorded that leaving oil undeveloped, i.e. in the ground, leads to a reduction in the number of barrels of oil consumed globally. And that's just after the Milieu de Fonsi case reference towards the bottom of that paragraph. Your lordships and ladyship will see there the reference to the reduction in the consumption of barrels of oil overall. And so, if oil is not extracted, because at this stage, this early stage in the process, its impact of the downstream greenhouse gas emissions is taken into account, then that will prevent or reduce the level of greenhouse gas emissions globally. Now, just pausing there, obviously the decision maker having that information, the extent of the downstream emissions before them, will not predetermine whether planning permission is granted or not. It will simply inform the decision maker as to the extent of the downstream emissions, so that can be taken into account. What is also agreed in relation to climate and greenhouse gas emissions is that climate change poses an urgent threat. And that is mentioned in each of the respondents' written cases. The science indeed shows this, and for the court's note, that's at core volume 103 to 105 in our written case.
Yeah. Sorry, may I just take you back to paragraph 71 of the
Yes.
Or just in England, senior president of tribunals, because in paragraph 71 he makes 2 points, I think, or at least 2 points material to the submission you're making. One is that one may calculate a theoretical level of greenhouse gas emissions from the combustion of a given quantity of hydrocarbons.
Yes.
That's one point.
Yes.
But secondly, whether the oil extracted from the development will be responsible for a net increase in global greenhouse gas emissions is a different question,
Yes.
and one about which it is not possible to make not impossible to make a reliable estimate, but one is only doing the best one can there to estimate it.
My Lord, yes. So a couple of things there, if I may. The first is that in the first iteration of this case before the High Court, there was a submission made that essentially there wouldn't be an increase as a result of the extraction of the oil. That, if I may speak colloquially, was put to bed by the time we got to the Court of Appeal. And in this paragraph, the senior president makes the point very clearly that that's not an operative issue anymore in the decision making, and indeed that is very much in line with the international case law, where that sort of substitution argument has been shown simply to be incorrect. with an eye on the time, your Lordship, though unerringly, picks up a point that I was going to make but had decided to gloss over, which is that first point about estimates of the greenhouse gas emissions of the combustion of the refined oil can be made. We had understood that, in fact, to be agreed, and it's reflected in this part of the Senior President's decision being included in the Statement of Facts and Issues as agreed. Horse Hill Developments now steps away from that in their written case, see Call Volume 199.
It's set out in paragraph 33 of the Statement of Facts and Issues.
Yes.
On page 89 of the bundle.
Yes, it is. And in my submission, it's incorrect for Horse Hill to submit in their case that the assessment of downstream greenhouse gas emissions is, quote, unworkable, because it's impossible to accurately assess the end-user greenhouse gas emissions at the production stage. That's simply not right. It's not what's agreed. It's not what the Senior President found. And the court has the IEMA guidance, that's Core Volume 900 onwards, and the Greenhouse Gas Protocol, which is listed in the IEMA guidance, which gives a well-understood methodology for doing the assessment.
And I think Dr. Solder, in her witness statement, does actually carry out that computation, doesn't she?
My lady, yes. She calculated a reasonable estimate based on what could be produced in light of the planning permission. She said it was 3,306,000 odd tonnes of crude oil, which she then said would give rise to around about 10,643,000 tonnes of CO2 equivalent over the 20 years of the production. That was an estimate, of course, because she wasn't dealing with the extent of information that would have been available to Horse Hill had it undertaken the assessment.
Sorry, do you have a bundle reference?
Yes, I do, for all of that. Core Volume 1015 at paragraph 54 is the 3 million tonnes of crude oil, and Core Volume 1016 to 1017 is the 10,600,000 tonnes of CO2e. All I've done there, my Lord, is add up the values in the table. My Lord, finally, by way of factual background, I was addressing the court on the context of climate. I won't repeat what's in the appellant's written case, either about the science or about the case law. That's at Core Volume for your notes 102 to 103. But in response to various points for the respondent, I should say this. It's important to explain why we've included in our written case the science in the detail that we have. And that is because this forms part of the context within the EIA regulations themselves, in which the statutory interpretation that is required in this case takes place. Climate is the environmental factor at issue. And so the nature and magnitude of greenhouse gas emissions and the extent of the environmental impact in issue is relevant, but the appellant has never contended for some sort of climate exceptionalism in the way that the regulations are understood.
What do you mean by that?
What I mean by that is that the respondents suggest that the appellant's case is based on treating climate differently from all other impacts, essentially. And the appellant's response to that is that's not right. Climate is not a special case, but when you're understanding indirect effects on climate, you have to do that in light of how climate impact works. One does the same with every impact. If you're understanding air quality impacts, you have to understand that against the background of how air quality impacts work. And in fact, this point is made good when one considers the type of inevitable, significant indirect effects that, as a matter of routine, are assessed under environmental impact assessment. For example, and these are set out in the appellant's written case, for your notice, call volume 125 to 126, but I'll just touch, if I may, for a few minutes on the detail of a couple of them, because this, I think, illustrates the point. First, socioeconomic impacts are routinely assessed. This is because they are population impacts, impacts on the population, under Regulation 4.2 and Schedule 4, Paragraph 4. And these would include, for example, the indirect impact of any new large out-of-town retail on the high street, usually a harmful impact. They would include the indirect impact of large-scale housing development on the local economy, usually a beneficial impact. Biodiversity impacts, for example, of newly located residents who now live close to a sensitive site, visiting the site. Those are indirect impacts that are, as a matter of course, assessed, and air quality impacts, including the indirect impact of increased traffic or potential congestion arising from new development. And indeed, paragraph 107 of the appellant's written case focuses on that traffic impact on air quality, because it is possibly one of the most common EIA impacts that one finds in practice. But it is dependent on a numerous intervening stages. Outside the development's control, outside of its boundary, and in fact dependent on other manufacturing processes. So it depends on the people living in a development, a housing development, buying a car, the car being manufactured, the engine producing emissions, or the particulates from the tyres on the road being produced. None of this causes any difficulty in that indirect effect routinely being A, acknowledged as an indirect effect, and B, assessed, because there's well understood methodologies to do that. And the court will see where this is going, because there is a direct analogy here. It is absolutely the same in relation to the downstream emissions of fossil fuel extraction for commercial purposes.
Except that the air quality and the noise and the effect on the biodiversity is all fairly localised, whereas the effect on climate is not particularly felt in Surrey. It will be felt first in some little island which becomes submerged in the ocean somewhere.
My lady, yes and no. Yes, that climate impact is not localised, and that's one of the reasons that we say that the climate context, this factor, has to be understood when understanding indirect impacts. But it's not right to say that the climate impact is differentially felt across the world, for this reason. If the oil was combusted in a car in Surrey, or the oil was combusted in a car in South Africa, the same greenhouse gas emissions would be emitted. And overall, the same harmful greenhouse gas impact from a worsened climate would be felt in Surrey, through flooding, perhaps, as in South Africa, through drought, perhaps. That is just the way that climate impacts work. It is not the case that the extent of the... Well, I think I've made the point.
Could I just, on that, ask you about the preamble to the EIA directive, because that talks about, at recital 15, so I'm looking at page 1231, about environmental impact in a transboundary context, take account of developments at international level. I just wondered how that fed through into the directive and what the directive requires.
My Lord, yes, there was a little bit of debate about transboundary impacts, but not much in the courts below. The appellant's case is that the inclusion of transboundary goes back to that first, or one of the early propositions, which is that explicitly the whole field of effects is sought to be covered, including those that will apply not just in the country of assessment, but in a transboundary way. Transboundary means two things, my Lord, to put it shortly. First, it might mean a project which crosses borders in a physical way, but it also means, in the appellant's submission, a project which has an impact that goes beyond the boundaries of the particular country.
Well, I think it means that if in Europe, the rest of Europe, you choose to build your big chemicals factory close to the border, knowing that the wind will blow all the toxic fumes into another country, that's not a reason for the planning authority in the country where it's going to be built to just ignore all those, saying, well, they're that country's problem, not our problem.
Yes, and your ladyship neatly encapsulates the climate impact.
And do we get any assistance from the Convention on Environmental Impact Assessment in a transboundary context?
Only to the extent that it is included within that basket of effects, to which I keep saying I'm going to take the court. I will take the court next to the actual wording of the directive and the regulations, but only to the extent that it is included within that set of effects. And if I may take the court to within the regulations, if that works, because essentially the same wording is used and the same extent of effects are covered. It's core volume 1291.
Go look at the 2017 regulations.
Yes, in the 2000 in the EIA regulations. So yes, in the domestic regulations, but as amended. And your lordships and ladyships will see 1292 after the list of the description of likely significant effects on the development on the environment is this: the description of likely significant effects on factors specified within Regulation 4.2 should cover the direct effects, and then this list: indirect, secondary, cumulative, transboundary.
I'm sorry, we don't.
Is this the right reference?
You've lost us.
Not the right reference.
CV 1292.
1292.
That's part of.
Then I will repair to the electronic version.
1298. Yes, we've got that.
Yeah.
1298.
And then
Paragraph 5, 1297. Is that?
Yes, 1298. So there's E, F, and G at the top, and then the description of likely significant effects on the factors specified in Regulation 4.2. My apologies.
so just to be clear, is it Regulation 5 you're inviting us to look at?
Yes, it's paragraph 5 of the schedule. Schedule 4. Paragraph
Sorry,
5.
that's a paragraph.
My apologies.
Okay.
Schedule 4, paragraph 5.
No one's referred, as far as I could see, to the second sentence of that full-out section. This description, that's the likely significant effects, should take into account the environmental protection objectives.
Yes.
Now, I would think that would mean that if you were building one of the other ones in 1291, an installation for hydroelectric energy or for harnessing the wind power for energy production, capturing carbon dioxide streams, etc., that if you were building one of those, you would be saying to the planning authority, well, there may be a little bit of emissions in building it and running it, but look at all the carbon emissions that we would be saving once we've built it.
Yes.
And that those, that would that fall into this sentence about taking into account the environmental protection objectives?
It would twofold. It would be taking into account the environmental protection objectives, i.e. the no harm principle, but it would also fall into a positive, indirect, potentially transboundary effect.
Yes, but if that's an indirect transboundary effect, then you would say if there's an adverse effect, that also should be taken into account.
My lady, yes. As we are in the regulations, may I stay there and move on to the general submissions that are relevant to the whole of the appellant's case, and start with the plain meaning and the context, both of which are drawn from the regulations. The submissions in relation to the directive, to which I haven't gone, contrary to the wishes of my Lord Sales, but they're all set out in the appellant's written case. That's Core Volume 109 to 110, and I won't repeat them. But within the EIA regulations themselves, if the court turns to what I hope is 1280, yes, Core Volume 1280, the court will there see Regulation 4.2, which has been mentioned a number of times. And that identifies what must, in an environmental impact assessment, be identified, described and assessed in an appropriate manner in light of each individual case, and those are the direct and indirect significant effects of the proposed development on the listed factors. Pausing there. There are two important things that the appellant takes from this, and indeed from all the statutory interpretation that we're going to undertake. The first is that there are some words in the directive that explicitly identify where there is discretion given to the decision maker. So in that regulation, it must be done in an appropriate manner. That is an explicit giving of discretion in relation to each individual case. And then the effects must be either direct or indirect significant effects. And that, the court will be aware, is one of those gatekeeper words that I mentioned earlier, where there is elasticity in the term. What significant will mean in different circumstances is a different thing. But indirect and direct, paired there together, are not areas where there's explicit judgment given, nor are they words that are elastic. And one looks through each of the next set of regulations that are relevant. So that's Regulation 4.2. The next is 18.3 and 18.4, and then into the schedule we just looked at. And on each occasion, there are words where there's explicit discretion given to the decision maker, and there are words that are not elastic.
And sorry, what's the bundle reference for that?
So apologies. 18.3 is CV 1284. And there, one sees that the environmental statement must include at least a description of likely significant effects. Those are the elastic words, likely significant effects on the environment.
But this is in the judgment at this point of the developer.
Yes, because EIA is that process of different steps. First in the judgment of the developer, then in the judgment of the consultees, because consultation is a key part of EIA, and then in the judgment ultimately of the decision maker. And that 5-step process altogether gives the information that's before the decision maker.
Sorry, why did you say 5-step process?
So the 5-step process is, the first step is the developer, the second is consultation, and then the last 3 are all for the decision maker. So that is identify, take into account within the decision, so record, and then make the decision in light of, essentially. I am paraphrasing.
They call it integrating.
Integrating.
Yes.
Your ladyship is ahead of me. (18.4), if I may just make the rest of this point, requires that an environmental statement must include the information reasonably required for reaching a reasoned conclusion on the significant effects, pausing there, plainly all words that explicitly give a significant degree of discretion to the decision maker. On the environment, taking into account current knowledge and methods of assessment. And those are the gatekeeper functions to which I referred earlier. And then Regulation 26, which is on the next page, CV 1285. And this is the stage that your ladyship, Lady Rose, was dealing with. The integration into the decision in the opinion of the relevant planning authority. But 2 points must be noted in relation to each of these provisions. The first is that none of the discretion applies to the meaning of indirect effect. And second, that the discretion does not extend to excluding a likely significant indirect effect completely from assessment. And that's what Mr. Willers will deal with in relation to ground 3.
Can I just ask, in relation to what you were saying about EIA in respect of, say, residential development, where you talked about impact on air quality from cars?
Yes.
Is it a requirement in those contexts that the greenhouse emissions effect of the cars has to be taken into account in the EIA as well?
As we're focusing on the specific nature of fossil fuel development, that's not something that we would put forward in particular. But I, as a matter of principle, see no reason why it would be excluded as an indirect effect. The question would be whether it is likely or significant. And of course, when one juxtaposes the extent of greenhouse gas emissions from the extraction of oil in the commercial volumes that we're dealing with here versus the extent of greenhouse gas emissions that may be caused by the emissions from cars, we're dealing with very different sorts of impact. Similarly, your Lordship will probably have thought about
But
this.
sorry, just on that.
Yes.
I thought that your case was that, in principle, because emissions are an indirect effect,
Yes.
there does have to be some consideration of them in an EIA.
Yes.
It's only at the later stage that one assesses whether they're significant or not.
Yes, but let me make the rest of this point because I think it answers your Lordship's concern. The second and key difference between a fossil fuel development and the cars in your Lordship's example is that it falls within that 18.3 flexibility of not being able to assess the extent of the emissions given the information that is available. Because what cars will be on the road, whether they'll be electric cars or fossil fuel cars, is not, as far as I'm aware, at the moment, a matter to which there is a methodology of EIA assessment that is regularly applied. And so it may be that down the line, if that methodology were developed, that there would be a prima facie likely significant effect which would give rise to an assessment. But at this stage, my Lord, there is not. But that doesn't mean there's not an indirect effect.
But does the legal question depend upon whether a methodology happens to have been developed or not?
No, the legal question of whether it's an indirect effect or not does not at all. It is. The question of whether it has to be assessed and how it is assessed depends on whether the methodology arises. And that's why I say that the gatekeeper function of the extent to which greenhouse gas emissions for any development, not our case, but for any development, would have to be assessed, is not whether they're an indirect effect or not. It's whether they are a likely significant indirect effect in light of the methodological understandings and the information available at the time.
But at what point in the process of my Lord's example would they be discarded? Would that be discarded? Would the environmental statement produced by the developer have to attempt that for then the consultees or the decision maker to say, no, we don't think that's a factor because it's too small and too conjectural? Or, on your case, would it be open to the developer in the environmental statement to say, these are an indirect effect, but we're not going to do the work of trying to find out what they are because inevitably they're going to be insignificant or there's no methodology to do that?
Both.
Right.
And that's because what is a likely significant indirect effect is relevant at both the scoping stage, i.e. does it get in at all, and at the extent of the assessment stage. And the level of information that is available at those two stages is different.
But, sorry, just in answer to my lady's question, are you saying that the developer does have to attempt?
What the developer has to do on the appellant's case is think about the downstream greenhouse gas emissions because they are indirect effects. And then the developer will, on advice, come to a view and put that view forward. And either the view will be, yes, we think they may likely be significant and so should be assessed, or no, we don't think that they're likely significant and we can't assess them anyway because they're unknowable.
They'd have to say either.
They'd have to say either of those two things. And then it would be subject to the EIA process. The consultees would be able to engage with that. And so the public consultation purpose of the EIA would be addressed.
And does that happen?
Yes.
If you have a residential development, is there a statement in the developer's EIA statement as to whether what contribution the use of cars in relation to the residential development will contribute to greenhouse gases?
So it very much depends on the context. I cannot say in my experience that I have dealt with that, but it is.
Sorry, when you say it depends. Sorry,
beyond the realm
when you
of
say it depends on
possibility.
the context, I had understood your answer to be that in every case the developer does have to address that.
Oh, I thought.
And so there should be a statement. there will be greenhouse gases emitted from cars, but we can't assess them, and therefore we don't say anything more about them, or we can assess them,
Yes.
but they're not significant or not sufficiently significant.
Apologies. I was giving a very practical answer to your Lordship's question, and I should have been more careful. There are a number of different stages depending on the type of development. A big development, the developer might go to the local authority and say, what do you think we should include? We propose to include these things, and there will be a discussion. And indeed, that's what happened in this case. In other developments, the developer will just put something forward. It is not the case that every EIA will, from the beginning, cover every potential type of effect, even if it might arise. And that's why I said in answer to your Lordship's question, that it depends. But it doesn't depend on the legal meaning of indirect effect. It depends then on the application of that in the particular circumstances. And that's why this appellant addresses only the context or the class of fossil fuel development. Because that is what is at issue here, and that is where we say it is clear for the reasons I have given.
And you say it's measurable.
And it is measurable, demonstrably so. I had proposed at this point to take...
You said there were two things that you were going to draw from Regulation 4.2.
Yes.
The one was that the discretion is sometimes explicitly given to the... have you already done the second one? Or are you coming
yes. The second one is the elasticity of certain terms. So even though it's not obvious from the language that significant, for example, is given explicit discretion, not like in an appropriate manner, because of the nature of the term, it is elastic. And so discretion comes in at that point. But the appellant's case is that indirect effect is not an elastic term. That's the primary case, first route. Primary case, second route is, even if it is, it admits of only one rational answer in relation to fossil fuel development. And your Ladyship's point on that second aspect is addressed in the Monopolies and Mergers Commission case, which dealt with the meaning of a substantial part of the United Kingdom. That's in core volume 2833. I might, given the time, just ask the court to note that, because that there is where the court addresses, in a way we say is relevant to this, what an elastic term is and how statutory interpretation applies to that type of term.
2833?
Yes, core volume 2833, that's where it dealt with a substantial part of the UK. And then 2830, so earlier on in the decision.
2830 is where it starts.
Where it starts. Shows that it was dealing with a particular part of the United Kingdom, so a public transport company operating in South Yorkshire, whether that was a substantial part. And the core elements of that case on which the appellant relies is Lord Mustill at core volume 2835, who pointed out that the word substantial, that was the case in the word in issue there, was chameleon-like. He referred to the many shades of meaning in the dictionary definition. And the simple point is that that's very different from indirect effect. It is neither of those two things. And in the appellant's submission, it would not, and the court will see this in the middle of core volume 2836, where the court refers to or disparages giving a spurious degree of precision to a term. It would not, in this case, trespass on that to define indirect effect to include for fossil fuel development for commercial production the downstream greenhouse gas emissions.
When you say fossil fuel for commercial purposes,
Yes.
Are you limiting your submission there to a development of a particular size, a particular quantity of fossil fuel production, or?
It's those developments that either by their size or their nature fall within the purview of the regulations.
Yeah.
And I'm aware, my Lord Kitchen's point might come from a submission that's made by Horse Hill, suggesting that Lord Justice Moylan got a part of his judgment wrong, where he focused on commercial purposes. And that relies on a submission based on the Marktgemeinde decision. And the appellant's short response to that is that the error was not made in the way that Horse Hill contends it was.
And what's the paragraph reference to Horse Hill's case for that point, just so we can follow it?
If I can find the part of that in my note where I was going to address it, I will be able to give
Right,
that.
don't take up.
You come back to it if you're.
I'm
if it's covered anyway.
very grateful. Yes, I have it. It's at core volume 191 to 192, at paragraphs 20 to 22 of the written case. And it's also in the County Council's case, I am reminded. But if I may, let me deal with this point now while the court is thinking about it. If the court turns up the judgment on core volume 303 at paragraph 100, and I start at paragraph 100 because that's an important place to start.
The Court of Appeal in this
Court of Appeal in this case, Lord Justice Moylan's decision at 100.
That's CV 393, I think.
Yes, I'll turn it up again electronically. 393, 100. There, Lord Justice Moylan begins by looking at the extent of the project, and he correctly summarises the difference between Schedule 1 and Schedule 2 development and the reasons for that difference.
And we're definitely in the paragraph 14 class, are we here?
Yes, we are. And then if the court scrolls to paragraph 102, this is the part to which the respondents take issue, because the Lord Justice sets out Schedule 2, the reference there to deep drillings and surface industrial installations, and he contrasts that with Schedule 1, where the extraction of petroleum for commercial purposes in a stipulated amount is the key element, if I can summarise. But the Lord Justice's point in paragraph 102 is made by way of emphasis. It is not the foundation for his assessment or for his reliance on the fact that this is extraction for commercial purposes. And what the respondent's argument does is ignore or treat as surplusage this inclusion of commercial purposes in paragraph 14, which one sees above 101 on that page. This is the only time in the directive and the regulations that commercial purposes is included as a criterion for defining the project. And Lord Justice Moylan's reliance on that did not get anything wrong. The Markt Gemeinde case, which was not before the court for a very good reason, because it dealt with extraction for exploration, so not production, just makes the simple point that exploration is for a commercial purpose. There's no difficulty with that.
So, let me just be clear. Are you saying then that in a project such as deep drilling, which he refers to in paragraph 102, because that doesn't refer to the commercial purpose, the greenhouse gas emissions of that petroleum and ore and natural gas and shale would not be in direct effect?
No, not at all.
Oh, that's what I would have thought.
No, not at all.
So what is your case then on this relevance of commercial purposes?
So it's a short point, and the reason that we went here is because really of the criticisms that's made of Lord Justice Moylan, which we say is not right. Because we're dealing here with Schedule 1 development, the commercial purpose of the extraction is relevant because it is the definition of the project. But it is not the mere fact of commercial purpose, commerciality of the purpose, if I may put it like that, that means that the combustion of the greenhouse gas emissions for this type of development is inevitable.
I mean, is there what sort of purpose where you're extracting 500 tonnes a day in the case of petroleum or 500,000 cubic metres per day in the case of gas would not be commercial?
None.
I thought when you started your submissions that you were saying that because the project is the extraction of the oil,
yes,
and here we have the extraction of coal, petroleum, etc.
Yes.
So you seem to be using the word extraction as extending the project rather than commercial purpose of the extraction extending the project.
So the project doesn't need to be extended at all. The project is how it's described. It is the extraction. It may be that what commercial purpose does, and why the Court of Appeal addressed it in the detail that it does, is because it became a shorthand for understanding that this fossil fuel would be burned. So it may be useful for me just to say this, that whereas extraction for exploration will be for a commercial purpose to determine whether there's a viable resource, it may or may not be the case that the extent of what is extracted will be burned as an indirect effect. And I can make that good by reference to gas. So if I'm a developer and I'm exploring for gas, I may draw the gas out and flare it immediately on site, and then determine whether there's enough gas there for it to be commercial. That, in my submission, is a direct effect. Or I may choose to pipe that gas off, and it may be burned in a power station in the UK. It may be burned in a power station in Norway. That will be an indirect effect. But the commercial purposes here became central to what the Court of Appeal was talking about because it was focusing on Schedule 1, and it became essentially a shorthand for the court recognising that inevitability that this fossil fuel would be burned and would cause greenhouse gas emissions. So I've dealt in some detail with the plain meaning of the words. I have also, in the propositions and in the discussion with my Lord Sales, dealt with the context, and Lady Rose dealt with the context of that word of those words, which is the climate impact. I have touched on the purpose of EIA, which is the protection of the environment through the procedural requirements. The OEP references the explanatory memorandum to the regulations. That's just for your notes at Core Volume 321, paragraph 12. And the appellant also references the England's National Planning Practice Guidance. That's at Core Volume 11, at paragraph 58 of the written case. The County Council, in relation to purposes, states that the EIA directive and regulations prescribe a process and not an outcome. And that is partly correct, because of course EIA does not prescribe whether eventually the planning permission will be granted by the decision maker or not. But it is incorrect to say that in general EIA directive and regulations do not prescribe an outcome, because they do. The outcome that they prescribe is the provision of information to the decision maker about likely significant effects, so that it can be taken into account and the environment thereby protected. So while the senior president is correct when he states at paragraph 37, for your note, that's Core Volume 377, the senior president is correct when he says that the process of EIA is not an end in itself. It does have a purpose and a value in itself. So it may not be an end in itself, but it has a purpose and a value in itself. And that is why we say, indeed, the purpose of the directive and the regulations runs exactly in line with the submission that the appellant is making on the understanding of indirect effect within the context of climate. Finally, the intention of Parliament. My Lord Sales addressed that. I won't spend time on it. What I will just mention is that the result or the upshot of emissions being of downstream emissions being an indirect effect of fossil fuel development is that the EIA process will be in line with the commercial reality. In particular, the reality that fossil fuel companies already calculate and report their Scope 3 downstream emissions. They do so voluntarily for the court's note, that's Core Volume 1164. It's the second bar on the bar chart, Core Volume 1164. And it's referred to in the appellant's written case at paragraph 101.
So we're looking here at?
I'll turn it up. So this is the World Resources Institute document. And the World Resources Institute is, of course, the organisation that put together the Greenhouse Gas Protocol, which is the methodology that is most often relied upon. And it's a document, you see this at 1157, where the World Resources Institute has analysed the trends that it has identified through Scope 3 reporting in relation, in particular, to the US climate disclosure rules. In short, the court may be aware that in the commercial sphere, it's sort of in a parallel, well, no, I won't go that far. In the commercial sphere, there is also a procedural set of protections coming into play where companies are being required commercially to report their Scope 3 emissions. And essentially, the short point that's being made is that a lot of fossil fuel companies indeed 79% of fossil fuel companies in 2021 already voluntarily calculate their downstream greenhouse gas emissions. So the step of requiring through EIA downstream emissions to be calculated because they are indirect effects, where they will be likely and significant, will not be an impractical step, nor will it be a barrier to growth or a brake on development. With an eye on the time...
So just before you move from that, I mean, how is the planning authority to make an assessment whether they are going to be significant?
So the EIA process will help with that. My Lord Sales opens their can of worms, if I may put it like that, because there is a lot of discussion at this point about how the magnitude of greenhouse gas emissions is assessed. I can give you a short answer, which is it tends to be assessed against whatever the national carbon budget is, whatever the local carbon budget is, and there's a local carbon budget for every local authority area, and potentially against the sectoral budget.
Who sets the local carbon budget?
So the local carbon budget has been calculated by an organisation called the Tyndall Centre, which is a climate change specialist centre working out of Manchester University. And what they did was they looked at the IPCC global carbon budget, and then they used, forgive me for going into this detail, but they used a process called grandfathering,
I think
which allows the emissions to be...
I'm just going to stop you for a moment, if I may. Just step back for a moment. Does this apply to each local authority, or is it a choice by individual local authorities as to whether or not they adopt it?
So there is a budget which is published for each local authority.
I see. Yeah.
It is up to the local authority.
Published by the Tyndall.
Published by the Tyndall Centre, and then available to each local authority. And I must also say that the reason it was published in relation to local authorities is because they were working with a number of local authorities on the project. So it's available for each local authority. And then it's a matter for the way in which the impact assessment is undertaken, how the magnitude is calculated in relation to that local carbon budget. There is, I don't think it's in the authorities bundle, though it was referred to, there's the Bristol Airport case, looked very recently at whether there was an obligation to calculate against the local carbon budgets. GOESA, which actually is in the authorities bundle, also touches on that. And in short, Mr. Justice Holgate says that it's open to calculate against the local carbon budget.
Sorry, what was that later?
That's GOESA, which is the Southampton case, and it is in the bundle at 2465 to 2509.
So is this right, that these local carbon budgets, they're not official, they've been supplied by a university department?
Yes.
They may sometimes be found to be useful by
Yes.
a local planning authority.
Yes, although there is just one subtlety, which is that some authorities have adopted them in a more official way than others have.
What does that mean?
So that means that some authorities are either looking at putting them into their planning policies or have referred to them as a material planning consideration.
Can I ask a rather basic question? What does a local carbon budget show?
So it will show the entirety of the greenhouse gas emissions that can be emitted from every emitting entity within that local area.
Including indirect or direct effects?
Yes. Everything.
Within that area?
Yes. So it is a way through mathematics to attribute a certain amount of emissions to a location, even though climate impact is global.
And even though they may be burnt somewhere else?
Correct. Correct.
I'm just not following this.
I apologise. It may be easier also just to say that this is the way that the national carbon budget is calculated, although what the national carbon budget looks at is greenhouse gas emissions that will necessarily be emitted within the location of the United Kingdom. So it is locational,
Yes.
specifically.
And that's true of the local ones too, is it?
And that can be true of the local ones. So, but what happened, for example, in the Bristol Airport case was that obviously aeroplanes will fly in and fly out. They'll emit greenhouse gases along the whole of their route. And a certain amount of that will essentially be attributed to the location, even though that's not really how it works.
So is there one of these cases which contains a description of this that we could...
Just go east.
The Bristol Air...
There is some description in Bristol Airport. There's a little in Goisa. I apologise. What I've described is my experience of this type of analysis across a number of different projects.
I'm not doubting the value of it. I
No, I didn't
Could
mean
we
it
have
that
a
way.
bundle reference for Bristol Airports? Just
No, I can't, because the Bristol Airport case isn't in there, because it was just referred to for one part of the written case, but it can be provided. It is in the appellant's written case within the part to do with climate context.
well, since reference is being made to it, perhaps we should have it.
My lord, yes.
But just going back to your explanation of the local budgets, I became a bit confused. I think you said for the national budgets, it is territorial. So
Yes.
if oil was extracted in the UK but burnt in China, that wouldn't feature as a debit against the national budget.
Correct, and that's why the climate change...
But then you said, at one point, in answer to one question, I understood you said for a local budget, you would bring into account extraterritorial effects, but then in answer to another question, you said it's the same principle.
No,
that
I
applies to the
apologise if
national
that was the
budget.
impression I gave. That's not right. What is done for an effect that will not necessarily be localised, but will come from a local area, that apportionment of greenhouse gas emissions is applied to the local carbon budget. That was the airport example.
If we take this case, if you're
Apologise.
extracting fossil fuels
Yes.
and we don't know where they're going to be burned,
Yes.
how would that be taken into account by a local authority?
So a proportion of the fossil fuels would be attributed to the local authority area, and there is a methodology for doing that.
But how would you know how much to apportion? I mean, it could be everything.
I mentioned the grandfathering process. This is getting very technical, but that's the process that's applied. And indeed, there's a description of this, though not again in the bundle, in the Scope 3 greenhouse gas protocol guidance about how grandfathering can be used.
And sorry, do we have that in the bundles that we can look at?
You have the first two chapters of that. You don't have that part, and it can be provided. I apologise. I am aware that I've gone into some detail about the way in which this is undertaken in answer to questions. But the court doesn't need, essentially, if I may say so, to understand the technical detail at this level. All that needs to be understood is there are well-recognised methodologies for calculating the extent of the greenhouse gas emissions and for understanding their level of significance. And I do not understand that to be, or issue to be taken with that by any of the parties.
Well, I mean, I'm sure it is my fault, but I'm still struggling a little bit to understand by what criteria one judges the level of significance.
So that was the answer to the question, which was it tends to be via comparison to various carbon budgets.
But I think you said that the carbon budgets don't take into account greenhouse gas emissions outside the territory, either nationally or the local authority.
So that was the first part of my answer.
Right.
The next,
sorry, but that's right.
My apologies. That's right. That's right. But the next part of my answer is that that's not the only way that significance can be calculated. And for a large project like this, the overall impact of the extent of the greenhouse gas emissions as against the global carbon budget calculated by the IPCC is a relevant factor as well and can be relied upon.
But I mean, I don't know how the figures map out, but I would have thought that the specific contribution to greenhouse gas emissions from this particular project, which is quite a small oil well when all's said and done,
yes,
one might think would be tiny by comparison to Saudi Arabia, for example. So,
yes.
So how does the local planning authority judge its significance in that context?
So twofold. First of all, the small numbers have to be contextualized. If a single project is just a small percentage of a particular budget, that can still be significant.
Sorry, but when you say a particular budget, what budget are you talking about?
Any of the budgets where it will be a global budget or a national budget, for example.
Okay. Yes, sorry, do go on.
At all. In the Cumbria coal mine example, one of the ways in which the extent of the impact was being understood was against the whole of the sectoral budget for that type of coal emission. And what was said was that the emissions would essentially eat up the whole of that sectoral budget. So that type of analysis is undertaken.
And sorry, what's the page?
No, that's again my experience of having been engaged in the planning inquiry to do with the coal.
I see. So right. So there's not a reported case.
There's not a reported case because the case is currently before the courts.
Yes.
Although I'll have to remind myself whether West Cumbria Mining in its submissions said anything about that.
Yes, I can see. Thank you.
So now, with an eye very much on the time, in my remaining 5 minutes, may I address grounds 1 and grounds 2. Ground 1 of the appeal, this is the erroneous intermediate process restriction, raises the short point that an indirect effect is necessarily mediated by an intervening process, and so there is no basis for interpreting the meaning of indirect effect as excluding effects because of an intermediate process. And the appellant's submission is that the senior president indeed relied in his reasoning on there being intermediate or intervening processes, including refinement, as a reason for the downstream greenhouse gas emissions not to be an indirect effect. And for the court's note, because given the time I think I'll find it difficult to go there, we say it's made manifest in these paragraphs. Paragraphs 65 onwards on call volume 384.
This is paragraphs of what?
Of the senior president's judgment in the Court of Appeal.
Thank you.
And paragraph 66 on that page as well.
65 and 66.
65 and 66 in particular. And that's where the senior president refers to the emissions not being indirect because of a series of intervening stages between the extraction of the crude oil and the ultimate generation of the emissions.
Was that one of the points that was made in paragraphs 121 and 122 as then adopted in the review of the environmental statement? Don't worry if you don't know.
Certainly the fact that the emissions would be out with the site, out with the control,
Yes.
And essentially far away from the site itself was relied upon, yes. So what the appellant says is that Lord Justice Moylan's approach, which is at 127 of the Court of Appeal's judgment, at call volume 132, I apologise, that's not the right reference. That's the reference to our case. It's Core Volume 404, beginning at paragraph 135 of Lord Justice Moylan's judgment. We say that that is the correct approach, 135 and 136, saying that the intervening steps do not provide a justification for non-assessment. And that, in the appellant's submission, is the right approach. I'll touch briefly then on Abraham in my last 5 minutes. Can I ask the court, please, to go to Core Volume 1260?
I'm not sure that's what you're looking for.
1620, apologies.
1620, thank you.
The Core Volume references are my friend today. 1620. This is the very beginning of Abraham, and the court will see there what the case concerned, which was modifications to the Liège-Bissau airport in Belgium. And it's really question 3, which is on the next page, 1621, which is at issue, the proposed increase in activity of the airport, so not the modifications themselves, but what they would cause. Must the member state in question take account of that increase when examining the potential environmental effect of the modifications?
Sorry, where are you reading?
So this is question 3, just from the head note.
Right.
Question 3 from the head note. That's the question that was being answered.
Should you take into account an increase in the activity of an airport?
Yes. As a result of the modifications, so the physical modifications that were made to the airport.
Yeah, in effect, the airport's capacity was being expanded, I think, wasn't it? So
Yes.
There was going to be increased airport air traffic going in and out.
Yes. And I won't take the court to the Advocate General's decision, given the time. If the court can turn up Core Volume 1646 at paragraph 43, this is the key aspect of Abraham, and indeed other cases which adopt this, Ecologistas CAT, on which the appellant relies. It would be simplistic and contrary to that approach, i.e. the purposive, broad approach of the directive, to take into account when assessing the environmental impact of a project or of its modification only the direct effects of the works envisaged themselves, not of the environmental impact liable to result from the use and exploitation of the end product of those works.
But what he was complaining about there was the noise, not only the noise of the building works, but then the noise of the extra aircraft. I don't think, unless you correct me, that they were actually talking about greenhouse gas emissions from the aircraft.
No, they were not. And that is essentially a key point, my lady, because what the appellant does is employ the common law method of extrapolating underlying principles from this case, which dealt with a project that was defined by way of its physical works, so the first part of the definition of a project, and applies that to a mineral extraction project, which is the second type of project that falls within EIA.
Why didn't the court look at greenhouse gas emissions? I mean, everyone knows that there are significant greenhouse gas emissions associated with aircraft.
My Lord, possibly for the reason that it predated the amendment.
What, in 2014?
In 2014. Although...
the questions didn't ask them about that.
And the question didn't ask about that, indeed. So all we say is that the court employs, and indeed this is what Lord Justice Moylan did, you employ the common law method to apply Abraham and its principle, not to a project which is focused on the construction works, but here to a project which is mineral extraction. And when one does this, The end product, in that Abraham phraseology, the end product of the extraction is the crude oil at scale for commercial purpose, and the use and exploitation of that end product is its refinement and its combustion and the resultant greenhouse gas emissions. And so there is no rational basis, we say, for the principle in Abraham to be applied only to the first type of project, which is to do with physical works, and not to be applied to mineral extraction, given that it is feasible and workable and within the purposes of the directive so to apply it. The appellant's short point on ground 2 is that no part of the intervening steps between extraction and the downstream emissions need to be encompassed by the project or by the development consent for the downstream emissions of fossil fuel development to be indirect effects.
Sorry, can you just repeat that?
Yes, no part of the intervening steps between the extraction and the downstream emissions needs to be encompassed by the project or by the development consent for the downstream emissions of fossil fuel development to be indirect. So we do not have to say, to put it very bluntly, we do not have to say that the refinement is part of the project for the greenhouse gas emissions of the refined oil to fall within indirect effect. And to the extent that the Court of Appeal relied on the stages of the process not being part of the project as a reason for excluding the downstream greenhouse gas emissions, that was an error.
That sounds very similar, in fact, to ground 1. I mean, it is a distinct ground, is it?
It is a distinct ground because it focuses on the meaning of the term project, and it picks up a point that was put against the appellant and seemingly accepted by the senior president in particular, that because the refinement wasn't part of the project, the downstream emissions were not an indirect effect. Essentially, the refinement was a separate project and it should be treated separately.
Well, this was tied up with the paragraph 122, which said, don't need to worry, it's all going to be assessed at a later stage, which I think everybody now agrees is not actually right.
Yes.
Where do we get this in his judgment?
So, in two different places, my lord. In paragraph 33 at core volume 376, we say the senior president puts the point correctly. The extraction of crude oil for commercial purpose was the essential content and character of the proposed development. It was the project. But then we say he went awry because the remainder of that paragraph sets out matters, and the question that we ask is, why were those matters being set out and relied upon by the senior president other than as a basis for excluding the indirect effects or the downstream emissions as being indirect effects? And that point is made good when you read that paragraph with paragraph 47 on core volume 379. And that's where the senior president focuses entirely on the physical works, so the operational development, as the end product of the project, even though the permission included minerals extraction. So the two paragraphs need to be read together.
Just give me the other paragraph.
Yes, it's paragraph 47 on core, on core volume 379, paragraph 47. So the court will have seen that what we say in effect is that the regulations are not project-centric. They are as much effect-centric and factor-centric as they are project-centric. That may just be a matter of sophistry of language, though, so that's why I just mentioned it. The court has the references in the appellant's written case. With an eye again on the time, and recognising I've left Mr. Willers with just less than half an hour's worth of submissions to the court, unless there are any questions, I will stop there.
Thank you very much.
I'm very grateful.
Yes, Mr. Willis.
My lords and my lady, I'm going to address grounds 3 and 4, and perhaps I can give you an overview, but a brief one at that. Ground 3 focuses on the fact that commercial production of fossil fuel will necessarily result in a likely significant indirect effect on the climate from greenhouse gas emissions because of their scale, the inevitability of the combustion, and because the whole point of the project is the provision of that fuel for that combustion. Accordingly, we say this is a type of case like the case being dealt with by the Court of Appeal in Squire, where applying the term indirect effect correctly as a matter of law, the environmental statement was defective because it should have included a sufficient assessment of the effect.
I'm so sorry, you said a case like, I just didn't hear.
Well, a Squire-type case. So there is a case in the bundle, the Squire case, which I'm going to take you to, where Lord Justice Lindblom and the Court of Appeal concluded that there was, to use the words deployed in the Plan the Earth case, a patent defect in the environmental statement, because in that case, the Scope 3 downstream effects of the spreading of a byproduct, that being the manure generated from the poultry business, was not assessed.
Yes, thank you.
That manure being spread on third-party land and having obvious deleterious effects. And indeed, the senior president identified the Squire case in the principles he laid out in paragraph 15 of the judgment of the Court of Appeal. He correctly set out the position in paragraph 15.6, which you'll find at page CV 368 to 369 for your note. And the reason for the ground of challenge, ground 3, is that the court did not then adopt that approach in our submission. He did, when it comes to the senior president's judgment, paragraph 40 and 41, we don't see him adopting that principle or applying it, or indeed the caveat which he identified in the Squire case. And that was the caveat I'm talking about now, that an environmental statement which wholly fails to include any assessment of a likely significant indirect effect will be defective as a matter of law. Now, in this instance, we know that the developer's environmental statement explicitly stated that it was confined to the direct releases of gases from within the well site boundary. That approach, we say, is a simple error of law for the reasons already given by my learned friend, Mr. Hahn. In the alternative, we'll invite the court to take Lord Justice Moylan's approach and conclude that cogent reasons would be required for there not to be an assessment of the greenhouse gas emissions arising from the combustion of fossil fuel extracted from a project, and that in this case such reasons had not been provided. Then, just summarising what I'm going to say about ground 4, that ground addresses the key contradiction, we say, in the Court of Appeal's approach in finding that the downstream greenhouse gas emissions were not effects of the proposed development, as they could reasonably be seen as too far removed from the proposed development itself. I take that, or those words, from paragraph 66 of the judgment of the senior president, to be found at CV 384. So on the one hand, excluding those effects as indirect effects of the proposed development, but then still accepting that the downstream greenhouse gas emissions were a material planning consideration. We say, as a matter of law, the EIA...
I'm not sure at the moment, you're not actually making the submission,
No,
is that
I'm
right?
just
You're telling us
outlining.
what your submission is going to be, which I don't personally find a very helpful presentation.
Well, then I'll move straight into those submissions, and given that we don't have much time, that's a good steer, my lord. I was going to say something about the question of law or judgment, but given the time, I'm going to simply say this, that we endorse the Office for Environmental Protection's submissions in its written case, and particularly paragraph 30, which you'll find at CV 330. There is perhaps one other point that I would make, and that's this, that these submissions are clearly made in the context of fossil fuel extraction. The extraction of fossil fuels stands in a class of its own, we say, given the inevitable link to greenhouse gas emissions, and that greenhouse gas emissions are the main serious negative impact on climate. And you'll note that Greenpeace, in its written case, suggests that perhaps fossil fuel extraction cases could be described as sui generis, but class of its own is where we put the case.
To what effect, though? What is the consequences of it being part of it? So?
To the effect that, given the inevitability of the downstream emissions impact on climate, there can be really no doubt that those emissions are an indirect effect of such development. Can I say something very briefly about the case of Bowen West? Which
I think you have half an hour, according to my timetable. You don't have to finish at 12, if that's the assumption you were working under.
Oh, at 12:30?
No, you have till 1 o'clock.
Yes, I appreciate that.
Yes, sorry. Thank you.
Thank you. I'm going to say something, if I may, about the case of Bowen West, which my lords and my lady will find at CV 1302 to 1314. And the judgment of Lord Justice Laws, particularly at paragraph 30. And you'll find that, my lords, at CV 1310. My lords, the Bowen West case was not a case concerning, and my lady, the Bowen West case was not a case concerning fossil fuel extraction, as you'll appreciate. But it's interesting in this sense because there, the submissions were being made in the context of the grant of planning permission for the disposal of low-level radioactive waste at a landfill site, where the developer had decided it would in due course seek permission to extend the period of the proposed works, as well as a major extension of the landfill site. The effects of the intended further proposals constituted indirect, secondary or cumulative effects, and that the project extended to not just the scheme for which permission had been sought, but also the scheme which it was proposed permission would be sought for in the future. Lord Justice Laws at paragraph 30 noted the submissions made by Mr. Drabble in that case for the challenger of the decision to grant planning permission. And you'll see there that Mr. Drabble's submissions, had they been accepted, would have required the court to say that in any case where it's intended to continue or supplant a limited scheme with a larger one, the effects of the latter need to be treated as cumulative effects of the former. That's a very different submission from the ones we make, and a very different type of case to the one before your lordships and my lady.
Wouldn't that depend on the planning structure of planning control in the particular member state? I mean, if you could show that under your planning laws the fact that you'd had this little scheme meant that you would almost inevitably get permission for the bigger scheme. Might that make a difference?
A foot in the door, as it were.
I think he uses that expression later, doesn't he?
We have a number of instances where the court has considered whether or not, as it were, particularly in the context of fossil fuel production, the grant of planning permission for exploration might inevitably lead to the grant of permission for production. And in those cases, and I'm thinking particularly about the Preston New Road case, or colloquially known as the Frackman case, the court has concluded that each element, as it were, exploration and production, should be treated separately and assessed on its own merits. And in those circumstances, one should not treat a proposal that may or may not be forthcoming in the future as a part of the project, or indeed something which should be taken into account as cumulative, a cumulative effect. And that's exactly what was concluded in this case. Indeed, when one looks back at page 1309, the previous page in the core volume, one can see at paragraph 26 that Lord Justice Laws said this: all these considerations, in my judgment, point to the conclusion which I regard as inescapable, that the project in this case is only the proposal contained in the July 2009 application. He goes on to say, and I would so conclude whether the issue is one of law or one of judgment for the Secretary of State, and in the latter case, whatever the appropriate standard of review. We say, as does the Office for Environmental Protection in their written case at paragraph 29.2.3, that's core volume page 329, that the judgment itself, and indeed the words of Lord Justice Laws, were very much angled, to use the Office for Environmental Protection's words, at the application of the term cumulative effects rather than its meaning. And here, your Lordships and my lady need to grapple with the meaning of the word, or the term, I should say, indirect effects. Lord Justice Laws at page CV 1311 refers to the judgment of the Deputy Judge in the court below. And at paragraph 33, but over on the page 1311, halfway down the page, there's a quote from another case which we have in the bundle, the Brown case, indeed it's the next authority, and the judgment of Lord Justice Sullivan. The Brown case concerned the approval for a freight distribution centre subject to a Section 106 agreement which required runway improvements and the development of a terminal building at Carlisle Airport. In that case, the environmental statement hadn't assessed the works in the Section 106 agreement, or indeed the impact of their use by aircraft flying in and out of the airport. The Court of Appeal in that case held that the grant was unlawful as there had been a failure to comply with the EIA regulations. And one can see that when it came to the judgment, and indeed the question of what are the cumulative effects of a particular development, Lord Justice Sullivan there said that there will be a question of fact in each case. But in the context of the facts before the court, he concluded that there was only one rational response to the question of whether or not the project included the works in the Section 106 agreement. And as my learned friend, Mr. Hon, as noted, there are two routes, we would say, to the conclusion that, as a matter of law, the indirect effects flowing from the project in this instance we're concerned with, the commercial extraction of crude oil, lead to greenhouse gas emissions. And the second route being that there is only really one rational response to the question whether or not greenhouse gas emissions arising from the combustion of oil are indirect effects. So what we say in essence is that when one looks at the Bowen West case, and indeed the Brown case, there is really little tension between those cases and the appellant's primary case in this instance. There was only one rational response to the question whether or not the greenhouse gas emissions arising from the combustion of oil produced at Horse Hill with an indirect effect. The answer being yes. Now, we put before the court a number of authorities from various international judges in Australia, United States, Norway, and others. There's one case perhaps that I would take you to very, very briefly, and that's the Nature and Youth Norway case, which, well, perhaps I can just comment on it because rather than taking you to it at this stage,
Could you just give us the reference?
Yes, certainly. We'll find that for you. Sorry, forgive me. We have it in the supplementary bundle. And it's right at the back of that bundle. Page 163 onwards. And can I just...
I'm not sure I have a supplementary bundle. Sorry. It's separate from the main bundle.
Oh, it's called, I think in our folders it's called Volume 3 Authorities.
Oh, right, okay.
Thank you very much.
CV 121, I think. It's twice.
It's certainly in the supplementary bundle at page 163.
Yes, I think in the supplementary bundle, or bundle 3, we have a longer version of the judgment. So I think that's perhaps the best version to go to. If
we've got that now, thank you.
I'm grateful. I mean, the short point is that 15 judges of the Supreme Court of Norway concluded that downstream greenhouse gas emissions arising from the combustion of oil extracted in Norway were an indirect effect which would require assessment in compliance with the EIA directive before a production and development order, or PDO, was granted. And one can take that from paragraphs 241 and 246 of the judgment of the majority.
And where do we find those?
You find paragraph 241, my lord, at page 199 of the supplementary bundle, where the lead judge for the majority said, "My conclusion is that no procedural errors were made relating to the climate effects during the impact assessment for the opening of the Southeast Barents Sea in 2013. The climate effects are politically assessed on a continuous basis and will be subject to an environmental impact assessment in connection with a possible PDO application." The word possible is used there because the question would be whether or not a PDO application was ever made, and it would depend very much on whether or not reserves which were commercially viable were found during the exploration process, which was subject.
Well, was there an argument in that case similar to the one here about whether these were indirect effects within the scope of the
Yes, very, very much, my lord. And indeed, the minority of 4 judges concluded that the greenhouse gas emissions arising from the exploration process themselves should be taken into account as indirect effects.
I mean, this is a long judgment. It'd be helpful to know the paragraphs in which the particular issue my lord raised were discussed.
Certainly, my lord.
Just to know, you said that they're considering the EIA directive. Of course, Norway isn't an EU member state, but are they looking at the same instrument because it applies in Norway because of the association agreement with the EU?
Yes,
is that how it comes in?
My lord, exactly. It was a decision of the majority, which I took you to at paragraph 241, and indeed it is reflected again in paragraph 246, which is over the page at page 200. When one turns to the dissenting opinion...
I was rather wondering about the reason that led to the conclusion, really, of the majority. Where is this issue discussed in the judgment?
Well, my lord, one doesn't see a great deal of reasoning that led to the 11 judges concluding at paragraph 2.
Well, where do we see the argument or the issue identified, the dispute between the parties being resolved by that conclusion?
We can go back to that, my lord. So
so it's 241, you say, that is them concluding that there has to be an assessment of the Scope 3 emissions?
Yes. One can see the issues...
I'm so sorry, I'm finding it just hard to understand what is being said in 241, because the opening sentence says no procedural errors were made, which presumably is looking at the particular project for which consent was sought. And then they seem to be saying there will be a later assessment of a different project, so this is doing the best I can, which will look at other things. So it just helped us.
My lord, yes, I mean, we can go back to page 165 and see the issues and background and the subject matter. And the case concerned the validity of a royal decree. That concerned 10 petroleum production licenses awarded for a total of 40 blocks or parts of blocks in the Norwegian continental shelf. And those blocks were licensed for the exploration for fossil fuel development. And the argument was that even at the exploratory phase, the downstream emissions arising from the oil produced during that exploratory phase ought to be taken into account as an indirect effect for the purposes of the SEA directive. Now, the majority of 11 judges concluded that that wasn't right.
Was not right.
Not right.
The challenge failed.
Yes, on the basis that it was premature and that if oil were discovered in such quantities as to be commercially viable, and then applications were made for what are known as PDO licenses, production licenses, then the greenhouse gas emissions resulting from the ultimate combustion of that oil outside of Norway would be taken into account as an indirect effect within the individual EIA.
Doesn't that suggest that the Norwegian court thought that the assessment of whether something was an indirect effect did involve some process of assessment? It wasn't just a pure matter of law, but on a sort of but-for basis.
Well,
because if it was, one might have thought that they would say, well, there's a reasonable chance that there will be oil discovered, it will be burnt downstream, therefore it is an indirect effect of the exploration that oil will be produced in that way.
Well, that's certainly not the way that I would suggest that one can read paragraph 241 and 246.
Well, you've just plucked out paragraph 241 from the whole judgment, and now you're starting to backfill gradually a bit of context which makes some sort of sense of the judgment.
Well,
it's still quite a long way to go as far as I'm concerned.
I understand, my lords.
So your short point is that they seem to be assuming that there was no need to consider all the downstream emissions at the grant of licences stage, because that would be taken into account when people applied actually to produce the oil from the section of sea that they were granted.
My lady, that's quite right, and it very much reflects the approach taken by the Court of Appeal in the Frackman case, where...
But sorry, doesn't it also reflect the approach of the majority in the Court of Appeal here? Because they talk about assessments being made, or potentially being made down the line when you look at the refining of the oil.
Well, no, the Supreme Court in the Norwegian case certainly weren't considering the possibility of assessment at refinement stage. They were...
All right, but they're looking at a later stage, and they seem to be saying there'll be an assessment at that later stage. That means that you don't need an assessment at the earlier exploratory stage.
Well, precisely because there was no guarantee that the exploratory stage would lead to the production stage. So we're effectively in that gatekeeping situation described by my learned friend. What is there to say with any certainty that the exploratory stage will lead to the production stage? And we come back now to the question of the foot in the door.
I mean, the trouble I'm having with this, and I'm scrolling through, this all is focusing on the Constitution of Norway, in particular Article 112, and also on provisions of the European Convention on Human Rights. I can find no reference so far to the directive with which we're concerned. I mean, unless there's some provision in the, there's the SEA directive.
My lords, yes, if I...
It seems to be, unless there's an absolute sort of parallel wording and a very similar context, there seems to be a decision on a different legislative regime.
Well, my lord, all I would say is that if one reads the dissenting opinion, one can see clear reference there, paragraphs 263, 265 to the SEA directive and the EIA directive.
Okay.
And perhaps that's as far as I can take it.
And just help us, what did the dissentient say? That there should be an EIA assessment at the exploratory stage. Is that right?
No, that the assessment should take place in accordance with the SEA at the exploratory stage, when the licenses were being granted.
So one's only concerned here with the exploratory stage, but
yes,
when it gets to production, things might be different.
Yes, and as I said, the majority appeared to accept that at the production stage, the greenhouse gas emissions would be taken into account as indirect effects. I don't seem to quibble with that. Can I then turn to the grounds themselves, and particularly the patent defect point identified in ground 3? As I explained at the outset, this ground focuses very much on the fact that, as in the Squire case, the EIA suffered from a glaring omission or a patent defect on our case, on our primary case. Squire demonstrates that the correct approach is that where there's a likely significant indirect effect, an EIA which omits assessment of that effect is unlawful. The project in the Squire case was for 4 poultry buildings and associated development. The project itself was inevitably going to create manure, and that was to be disposed of through use as a sustainable agricultural fertiliser.
And where is the Squire case to be found?
The Squire case, my lord, you'll find at CV 70. Begins at 1567, my lord. Apologies. And the points I'd made, one can see from Lord Justice Lindblom's judgment, as he then was. He begins with an introduction which explains the facts at page 1570, paragraphs 1 to 4.
Could I just ask you this on the facts of Squire? The manure, was that to be sold by the operators and would be applied in other areas, or was it just being applied on the local farm?
I'm told by my learned friend who was in the case that it was unclear as to whether or not it was to be sold. It was a byproduct of the process, but
how was it being disposed of?
well, it was being the idea was that it was to be stored, removed, and then
it was going
spread.
to be. Sorry.
Yes, sir.
Subsequent spreading of, I see the head note refers to the subsequent spreading of the manure on SC's land. Is that right? Is that what this was about?
Some of the, one can see from paragraph 3, page 1570, my lord, that Lord Justice Lindblom says in paragraph 3, about 7 lines down in that paragraph, the manure would be disposed of by spreading it on farmland close to residential areas on the west side of Bridge North, some of it not owned by Mr. Bower.
I see. Who's Mr. Bower?
I think he was the farmer,
What, the farmer?
the developer.
Yes. I follow, yeah.
So some of it was to be disposed and spread on the developer's land,
Yeah.
other on third parties' land.
Yes.
Now, spreading of the manure was not part of the application for planning permission. It didn't need planning permission. And the practice could occur in any event without the development taking place. But just pausing there, we shouldn't forget that the respondents in this case certainly rely on the fact that greenhouse gas emissions will occur outside of the development site and be caused by others burning the oil. But that didn't exclude the manure in this instance from being considered to be a downstream effect, an indirect effect. So,
And where's the nub of the reasoning in the case?
sorry, my lord.
Where is the nub of the reasoning in the case to be found?
Yes. Well, if we move on through the judgment, my lord, we'll find that Lord Justice Lindblom looks at the question of whether the EIA for the development was flawed at page 1587, paragraph 62 onwards, and paragraph 69 at 1588. He says, in my view, therefore, given that the environmental statement did not take account of the impacts of the manure, in my view, therefore, the environmental statement was deficient in its lack of a proper assessment of the environmental impacts of the storage and spreading of manure as an indirect effect of the proposed development.
I'm so sorry, which paragraph were you in?
Paragraph 69, my lord, at CV 1588.
Yes, thank you.
In this respect, he said, it was not compliant with the requirements of the EAA directive and the EIA regulations.
But as far as I understand, this point isn't a separate point about the defect. This is just a point that the defects which we've so far been looking at are sort of fatal to the grant of the planning permission.
Yes, it's a fatal flaw in the EIA process, which ought, just as in the Squire case, to lead to the conclusion that the EIA process was fundamentally flawed and that planning permission should not have been granted. And that is it in a nutshell, my lady. And looking at the time, I'm going to move swiftly on, if I may, to the alternative basis on which we put the case, but only in this respect. My lords and your lady will have read Lord Justice Moylan's judgment and his view that cogent reasons should have been given for the exclusion of the greenhouse gas emissions arising from the burning of the oil as indirect effects. He concluded that the reasons given in paragraphs 121 and 122 of the environment statement were insufficient. And we would just invite the court to adopt his considerations, adopt his conclusions, and conclude indeed that the reasons given by the developer and endorsed by the County Council were contrary to the broad scope of the directive and regulations and wrong as a matter of law.
Well, that's the first point. I thought this was a fallback point, that the reasoning was insufficient. So what would be the result of that if we agreed with you on that point?
Well, if you agreed with me on that point, then there's non-compliance with the regulations, non-compliance with the directive, and that would vitiate the decision of the County Council to grant planning permission. Then turning very briefly, if I may, to ground 4 and the material considerations point. Our simple case is that, as a matter of law, the EIA regulations causal question, that is, whether something is an indirect effect, is answered if the effect is a material planning consideration. In the case of Wright, which I think the court invited us to take some time over, page CV 1602, paragraphs 32 to 34. I'm not sure I'm going to have much time to do this job, but CV 1602, perhaps we can just turn it up. And my Lord Sales, this is part of your Lordship's judgment.
Oh, is it? Don't assume I remember any of it.
Well, I won't, my Lord. But here the court was dealing with the question of what constituted a material consideration. And when one reads through, and I'm not going to take you through the whole of the judgment, 32 to 36, one can see that for a consideration to be material, it must be for a planning purpose, and it must fairly and reasonably be related to the development. We say, quite shortly, if that is so, as a matter of law, then the effect cannot logically, as a matter of law, be too remote for the purposes of EIA, particularly given the breadth of the term indirect effect.
But doesn't the question of whether it's a material planning consideration depend on whether it is an indirect effect or not? If it's not an indirect effect, then it's not a material planning consideration.
This is a point that has been argued, I think, in the Cumbria coal case, with respect to the Finch judgment in the court below. On the basis that if greenhouse gas emissions are not an indirect effect, then they can't be a material consideration. And with respect, that cannot be right, but it's certainly an argument that's being deployed.
But are you saying that the local planning authority, in our case, treated
the downstream emissions as a material planning consideration, and therefore there's a mismatch.
Exactly. Well, that's the other way of arguing this point, that there's something arbitrary about the approach. We have, or an inconsistency in terms of the approach taken by the local authority. One can go back to the judgment of Lord Justice Moylan and see that he identified certainly discussion about climate change and greenhouse gas emissions, but only in a very limited way, whereas the planning authority took account of the positive benefits of the commercial extraction of oil from the development site, and specifically from the development site, given the planning policy need identified by the government for domestic extraction.
And can you just give us a bundle reference to where the local planning authority, in its reasoning, treats the downstream emissions as something which is a material planning consideration?
Certainly, my Lord. One can see, if one goes to the officer's report at CV 501 to 502, paragraphs 159 to 162 of the officer's report, that the Council gave the benefits arising from the development significant weight. See in particular the officer's report, paragraph 160.
Well, now, you're coming to the end of your time. You do have, in reply, an hour and a quarter.
Absolutely.
Eat into some of that, sum up your submissions at 2 o'clock, then, or as you wish, then that's you. But please, if you choose to take that course, let your opponents know.
Certainly, my Lord. I was going to touch briefly on the Office for Environmental Protection's call for guidance from this court. You have those submissions from the office in their written case. I may, if I'm permitted to do so, take 5 minutes just to address those at 2 o'clock.
2 o'clock.
But can I just be clear? You may want to come back to. When you say that they treated it, this mismatch between the council treating something as a material planning consideration, are you saying that they treated the benefits of the extraction of the oil as meeting the UK's demand for unimported, locally produced oil as a material planning consideration, and therefore they should have also treated the adverse effects? Or are you saying that they regarded even the adverse effects as a material planning consideration, but somehow didn't then treat them as having indirect effect? I'm a bit confused about where we are.
I'd say I was as well. I was reading these paragraphs. They don't seem to say, oh, and we must bear in mind that there'll be downstream greenhouse gas emissions.
They do not at any stage consider the downstream greenhouse gas emissions.
Right.
That wasn't part of the environmental statement.
So is it the first of my two alternatives? Right.
Yes.
They looked at the upside as a material planning consideration, and therefore they should have looked at the downside as well.
Exactly. In another context, the phrase is used, taking the plums and leaving the duff behind. They didn't look at the negative impacts in any way, shape or form, only took account of the positive benefits from the extraction of oil.
Mr. Willard, we're going to adjourn now and we will resume at 2 o'clock. Thank you very much.
Thank you very much, my lady.